Hey, everybody, and welcome back to the Legal Weekly Wine, where we discuss the week's hottest legal topics. This is Just Virginia doing a quick intro because when we started this 100th episode, we had one topic in mind and then it went to another. So what we're discussing today in this episode, our 100th episode, is the question, which branch of government has the ultimate decision-making authority as to what the law is, who enforces it, how it's done, and who can defy it, if anyone. We've got a current situation in the U.S. that's a legal issue with regard to the executive orders that have been made by President Trump and whether he is going to be following court orders, whether district court level, circuit court level, or Supreme Court level, that will be issued and have already been issued regarding his executive orders. Who has the ultimate say as to whether those orders are constitutional and what happens to them? And can Trump defy them? Has any other president ever defied a court order before? And what does history say regarding our ultimate law, the Constitution? We know that politics is often combined right now with legal questions, but we're taking this back to the beginning. What did our Declaration of Independence mean? What were the rights we were fighting for in the American Revolution? And where does that lead for our current legal and political situation? So join us for this special episode where we start off with some fun with questions and answers regarding the presidents, former presidents, and their history, with the upcoming anniversary for the Declaration of Independence, and then the ultimate questions. We hope you enjoy the episode and stay tuned with us for just one more second. Hey, everybody, and welcome to the Legal Weekly Wine, where we talk about the week's hottest legal topics. And today we are celebrating a couple of momentous times and occasions. First and foremost for us, this is our 100th episode. So, yay! Congratulations to us. Yeah, I know. For those of you who can't see and who are only listening, Dr. Vile's in the background blowing, fake horns and sprinklers. Confetti is flying, fake confetti. It's great. It's great here. I like it. So we're celebrating the 100th episode. And with our celebration comes a couple of other celebrations. So this last week, we celebrated President's Day. And Dr. Vile is very excited about that. He's my co-host. Why? What? Okay. This is like asking what you did on Labor Day, but what did you do on President's Day, Dr. Vile?
Well, Labor Day is obvious, right? You're supposed to work.
Yes.
Okay, when's that word going to get out? President's Day. I don't know that it was actually the day, but I got to speak this last week to the Sons of the American Revolution, who always treat me very well. And I thought I was going to get by with just giving my speech and moving on, but I noticed there was cake there.
I had to stay,
obviously. And much to my pleasure, we sang Happy Birthday to George Washington.
That's incredible.
And that was great. And then Saturday, we had a group of incoming scholarship students known as the Buchanan Fellows in the Honors College at Middle Tennessee State University. And they came for a special breakfast, and I had each one stand and tell us a little bit about themselves. And then they had the pleasure of either answering or trying to answer a question that I threw out about American presidents.
Nice.
Or they could ask me one and see if they could stump me. And so we had I had a good time with it. I think they were petrified, but I very much enjoyed it.
Did anyone stump you?
I got a question from a father that I think if it had been worded differently, I could have gotten, but I didn't. And the question as he phrased it was, which president was a professional wrestler?
Oh.
And so when I think professional, I think WWE.
Right.
Current has to be somebody recent president. So if you take the word professional out, which president wrestled and was pretty good at it? You have any idea who it was?
My only guess would be Teddy Roosevelt, but I don't know.
That would have been and I'll give you another one that I got, which would be good. But it was actually Abraham Lincoln.
Oh my goodness.
He was very well, and you can imagine as big and
Oh, his
sort of
height.
gangly as he was. But wouldn't that be a resume builder? I wrestled with Abraham
Abraham
Lincoln.
Lincoln.
And, if I told my classes, some of them would probably believe it, How old is he? Yeah, that's possible. But the other question that I wasn't sure that I had right, I didn't hear it right first, but then it was which president worked to preserve college football? And I remembered a book that I had read that in the early part of the century, remember, well, even today, right? We have concerns about athletes who retire and then have brain damage and
Right.
you commit suicide and those kind of things. And particularly at the turn of the 20th century, the helmets were not nearly as
Mm.
good as they are now. The rules were not quite as advanced as they are. And it was actually Teddy Roosevelt, as you would
Oh,
expect,
interesting. So
who
now we're
helped
at Teddy.
who helped preserve that sport.
Nice.
But if anybody wants to submit some presidential questions the one that was the most fun. But I think this from from a class that we were in.
Okay.
Um, which president, according to the instructions on the toy, could no longer play it? You remember we talked about this before?
I don't think we have.
Okay, so there is a president that if you followed the instructions on the box would be unable to play.
Oh my goodness. It has to do something with eyesight.
No, no.
I don't know.
Okay. You should know from your sons. What's their favorite game?
Xbox, virtual
No,
reality.
physical game.
Oh, physical game. What is my son's favorite physical game?
Oh, particularly one of them. He's obsessed with it. He spends all his money on it.
Legos?
Yes.
Oh, okay.
Okay.
I'm thinking more football, soccer.
No,
Okay, not
no.
outdoor game. Okay.
So the box says 4 to 99.
Oh, so Jimmy Carter?
That's right. Jimmy Carter lived
Aw.
beyond 99. So if he followed instructions on the
Oh,
box, he
that's
could no
so
longer.
cute.
And that's probably what did him in, right?
Oh,
I
he
mean,
couldn't. Yeah, he
what
couldn't play
value would life
Legos.
be if you couldn't? Yeah.
Yeah,
couldn't
that
play
is
Legos?
true. That is
Yeah.
true. Now let's go back to our final anniversary that we want to discuss, which it sounds like even political science professors aren't aware of. It's not at the front of their minds.
In fairness, they're probably more worried about getting midterms done and those kind of things.
Fair.
But partly because I was married in the bicentennial. And one of the fun things about the bicentennial for political scientists is that often people will get a little bit more excited about America's founders. And it actually took 11 years for me. But in 1987, there was a conference in Mexico City comparing the U.S. Constitution with the Mexican Constitution, which is started in the 1917.
Okay.
So it's an anniversary of both of them, and I got invited to a conference there. In part, if I can give some thanks to someone,
Please.
to Walter Dellinger, who was a lawyer who eventually became Solicitor General and is now he's passed away, but his son is the one who has gotten the case to the Supreme Court. But he had been invited to go to this and couldn't, and he knew that I had written on the amending process, and I got to go there for about a week to celebrate the Constitution's 200th anniversary.
Amazing.
So next year will be the 250th of the Declaration of Independence, and here's why it's relevant.
And this is so everybody knows the specific term is the semi-quincentennial.
Right. So
250
and it's a
years
wonderful
of our
teaching tool,
Constitution.
by the way, if you have kids, right? Quin means 5, centennial means 100. So, and then semi is half. So it's half of 500. The other possibility, which I thought they were going to go with, is sestercentennial. sesquicentennial.
And I can tell
Which,
you why they didn't.
yeah, well, because it's hard to pronounce. If I can't pronounce it, others can't too. And
If you can't, we're all doomed.
yeah, something like that. But yeah, but what I was going to say now, and this may sound a bit partisan, but in 1776, the great document that preceded the Declaration of Independence was Common Sense,
By Thomas
written
Paine.
by Thomas Paine, one of the most influential political pamphlets in American history. And prior to Paine, Americans since 1765-ish had been objecting to parliamentary sovereignty. They said, you go back to the Magna Carta of 1215, there's a right not to be taxed unless you're represented.
Sure.
We're not represented in Parliament. And the reason this matters is when Parliament passes a law taxing the colonies, they don't suffer the consequences. So the colonists said, you don't have that authority, but we're loyal. We want to retain our English rights. We're loyal to England. And how did they do it? They went back and said, well, the people who gave us our charters, it wasn't Parliament, it was the king. We remain loyal to the king. And right up through 1775, early 1776, they were still sending petitions, your honorable, your majestic King George III, surely you will hear the pleas of your people, remove these onerous taxes from us to, give us what we need. And of course, when he didn't do this, then the Declaration of Independence is directed primarily at George III, because we didn't even recognize. Now, there's a phrase in the Declaration that says he, meaning George III, has combined with others, and that's Parliament. But we had already rejected parliamentary sovereignty, and now we're saying we don't recognize the authority of a king, particularly an hereditary king, over us.
Interesting.
We think the people should be choosing their own rulers rather than just simply accepting somebody who gets it through heredity. And I think there is a good reason. Well, so perhaps partly in fun, but scary to some of us, is that I believe it was on X last week. You have a picture that's posted by Trump of him with the crown on his head saying, "Long live the king."
Right.
Now, again, maybe that's supposed to be funny. Maybe I don't. I think I have a good sense of humor, but maybe in some political issues I don't. But that's what we fought the revolution over.
Right.
And are we willing to invest similar kingly powers? Now, again, it would be better in the sense that it's an elected person, and you could presumably, they have limited terms if they follow the document, that sort of thing. But I guess what I'm worried about with the semi-quincentennial, I want to celebrate.
Absolutely.
I believe Declaration of Independence, is a major turning point, not only in U.S. history, but in world history. But I don't want it to be captured or hijacked by someone who's, someone who can tell us that Ukraine bears responsibility for being invaded could just as easily tell us that the Declaration of Independence was there to affirm executive authority rather than to rein it in.
Sure.
And so I have genuine concern. I mean, I don't want it to be used in a partisan fashion by either side.
Right.
But I think there are certain fundamental principles, and we all adhere to, right? All men are created equal. They're endowed, life, liberty, the pursuit of happiness, the right to revolution, the need for, common calls against to protect one's freedom. These are the values that should be celebrated.
Right.
It shouldn't be a Democratic or a Republican celebration. It should be an American celebration.
Absolutely.
And what's a little scary is 1976. I look back on that with fondness.
Which is when you were married. So that was the bicentennial.
Because I got to go to Philadelphia. I saw an early copy of the Magna Carta. We visited Independence Hall.
Which is what every woman dreams to do on her honeymoon.
Well, no, this was not actually the honeymoon. We went to Duke University on our honeymoon.
I'm just saying.
Okay. Tyrone Palace. I mean, in North Carolina, Governor's House. What? That's right. What more could a woman want?
Your wife, my mother, is a saint.
Yes, she is. Okay, we will attest to that. But the point I was trying to make right.
Sorry, I sidetracked us.
2 years earlier, we faced another president who wanted to exercise kingly powers. And it was only because of this, determination by people who practice law, like yourself and others,
right,
and a Supreme Court that 8-0 ruled he had to turn over confidential information, that we were able to have him resign from office and have a peaceful transition of power. To someone that Congress, and that, by the way, is one of the presidential questions that I didn't get to, but somebody asked me and I knew, and it was who is the only person who was president in the U.S. who was never elected as either president or vice president. And the answer is?
Oh my goodness. Or vice president.
Not elected to either office.
Well, if we're talking about Nixon, it has to be surrounding what, Johnson?
Yes. Pardon?
Johnson?
No, that's before Nixon. You
right.
Go
Sorry, that
Nixon.
was Kennedy. To Johnson.
Kennedy, Johnson, Nixon,
Ford,
Blank, and Carter. Pardon?
Ford?
Yes. Ford was appointed under the provisions of the 25th Amendment, which provides for replacement not only of a president, but of a vice president.
What happened to the vice president?
Spiro Agnew had to resign because basically he had taken bribes as governor.
Okay.
And this was revealed. And so he pleaded nolo contendere. And there may have been, now this is interesting. I think that the primary penalty that he took was resignation rather than having to go to jail or pay a fine. And does that at all relate? Now, you didn't mention this earlier, but this current controversy involving the mayor of New York.
Oh, right. Oh, my goodness.
Where,
right.
What appears to be happening is it appears to be that he has taken a bribe, 150,000 or so, chicken feed,
right.
from Turkey, and perhaps, but earlier corruption charges too. And I can't really attest to the validity or not, but they were the charges against him, and he hadn't been officially convicted. But it appears as though the Justice Department is dropping those charges with an understanding that Adams will fully cooperate with Trump's immigration policies. And the two are really not related in the, why do you let somebody off from jail? Because it would be sort of like saying, we'll let anybody who voted Republican,
right?
As long as you voted Republican, then we're not going to prosecute you, or the other way around.
Well, and this is one of the
prosecute any Democrats as long as they, support our policies.
Right, and this is one of the issues where we're getting into what are the judges saying. And it's very rare for a judge to refuse to drop a case should the prosecution come and ask for a dismissal. Usually there's high discretion for any prosecution to null pros or, dismiss a case without a finding, or simply to dismiss with or without prejudice. So if it's without prejudice, you could bring it back. If it's with prejudice, you can't bring it back.
Well, and can I bring in something else here, which
absolutely.
is my understanding is the government is actually, the Justice Department is asking that it be provisional, which means it's even of higher dubiety. Is that a word?
I'll take it.
It's more questionable because it suggests that if Adams doesn't give political satisfaction, that he could be retaliated against with a legal move.
Right, by the feds.
Yeah.
Yes. Yeah. And so this is this is highly unusual that in this case currently the judge has not yet ruled.
That's my understanding.
It has brought the prosecution in and demanded a reason for the dismissal. And right now that is pending, which is very rare because most of the time if a prosecutor comes in and says, we'd like to dismiss the case, the judge says, and this is usually state-driven rules, some federal-driven rules, especially in Maryland. I came up against this last year where we were, I was actually filing objections to the dismissal of a criminal case on behalf of a victim. And it was continuously put down because the judges said, you don't have authority. The judge doesn't have much authority. It's up to the prosecutor. They're using their discretion. So it's rejected.
And isn't even more complicated than that, which is, I got to ask you something first.
Mm-hmm.
Does a judge have the power to refer a prosecuting attorney to the Bar Association and say, so there's that. Yes. And then I lost the other thought. I knew that was going to happen as soon as I did it. So I shouldn't have gone that direction.
Well, but that's a good point.
I know what it is.
Okay.
If the Judiciary Federalist number 78, written by Alexander Hamilton, is said to have been the weakest branch of government. Even if you told them they couldn't drop the charges, you can't guarantee that the prosecutor would go full bore.
Correct.
And I mean, they could come in and just do a really sloppy case and they'd say, well, there's not enough evidence to convict. And the judge's order might be essentially meaningless. Now, if there's some kind of possibility under the law that he can appoint a special counsel, and that might vary. I don't know if
that's
that would
a consideration in this case, is to appoint a special counsel, at least to review the case.
Right.
I don't think that he can appoint special counsel to
prosecute
it. But I do think in this case, it would be appropriate to appoint special counsel who would be a neutral party, who has not touched the case before, is not one of the current parties, to review and investigate the charges and determine whether there is sufficient probable cause to move forward with the prosecution, or whether it is correct in analyzing the case to say, oh, there really isn't enough evidence. We don't think that we can win. And it's a fair dismissal.
Of course, and then that takes us maybe to where you're headed, which is, what if the judge appoints a special counsel?
Yes.
And
Trump
the president fires a special counsel.
Exactly. And this is where we get into the ultimate question. And Dr. Weil, who is my father, I'm Virginia Tarani, by the way, in case of those who don't know me. I'm an attorney, almost 20 years, been practicing in criminal and civil law, been a prior prosecutor. Right now I work at Tarani Law LLC because you never need a lawyer. It's how you do. We do mostly personal injury cases, but a little bit of extra. And Dr. Weil, who's my father, is the Dean of the Honors College at Middle Tennessee State University. You are an expert in the Constitution, the amending process, and constitutional law. So here is the ultimate question. Based on the Constitution, who has ultimate decision-making authority as to the other branches? So we've got the legislative, the judicial, and the executive.
Oh, no. Get them in the right order.
We've been through this. Legislative, executive, and judicial.
Okay.
Those are Articles 1, 2, and 3 of the Constitution.
Yes.
And you've just said there's an argument that the judicial is the least powerful of the three branches. Right. But of those three, does the Constitution say anything as to if there's a disagreement among the branches, who has the final authority and say?
It's tricky. The Constitution, and people are wrong on this, by the way. They'll say the Constitution created three co-equal branches. I don't think they were ever co-equal. To go back to the reason I objected to the order, it was generally thought that the legislative branch would be the most important. That's why we have a bicameral Congress, by the way,
Right.
to make sure it doesn't act precipitously. And then the president, the advantage of the president and the Congress over the courts is that they can initiate actions in a way that courts cannot. Courts have to wait. You can't, well, you sort of can. You can't legally lobby the Supreme Court or any other court in the same way that you would write a letter to the congressman or to a president or that kind of thing.
You have to wait until something has already happened.
That's right.
To be
They're a
reviewed.
reactive branch, and they can't always choose who's going to. Now, the system is so complicated. There's so many cases that it's a rare case, as de Tocqueville noted in the 1830s. It's a rare case legal issue that doesn't eventually reach the Supreme Court. But we have a written constitution.
Right.
And the advantage of a written constitution was that it would be enforceable in a way that just the sheer custom or usage might not be. So people could go to the court and get vindication. And the court has an advantage in interpreting two advantages in interpreting the Constitution. One is they are lawyers, which some might consider a disadvantage. But in terms of the law, I mean, they're trained in the law.
Exactly.
They know precedents. They're used to dealing with cases and controversies.
Right.
And secondly, they're not going to be running for office. So they don't have the same, presumably they can look more dispassionately at an issue than could either a Democratic or Republican Congress or president.
Presumably. Now, the trick is, especially in states, some judges are elected.
In states are often elected and they have shorter tenure, but particularly the federal judiciary, basically, you're appointed and confirmed. So there's a two-part process. You can be impeached, but otherwise, you're there till you die, you retire, or you would be impeached and convicted. We've never had a Supreme Court justice who's been so removed.
Right.
So generally, it has been understood, going back to Marbury versus Madison and even before, John Marshall says it's the duty of the court to say what the Constitution is, what it means. And there's some discussion, there's some dispute about this, but I don't think there has ever been a case where the U.S. president has directly defied the U.S. Supreme Court. Now, there's an apocryphal story that Andrew Jackson once said, the court has made its decision, let it enforce it. But as far as I know, that is apocryphal. Abraham Lincoln defied an order by Chief Justice Taney, but Taney wasn't acting on behalf of the court. He was acting as a circuit court judge at the time or whatever.
Interesting. Okay.
And we've talked about other cases, the Youngstown Steel decision in 1951 or two, I think it's 51, where Truman had seized the steel mills and the court said, no, you have to turn them back over. And, as late in the Bush administration, there were several actions that were taken against terrorists that ultimately were found to be unconstitutional. No, you can't take an American citizen, put him in Guantanamo and refuse to give them legal counsel.
Sure.
Deny them their rights. So, and to take another, now this is against the governor, but in Arkansas, Orville Faubus.
Back in
he tried
the
to
civil
close down the school system rather than integrate or put his own troops. President Eisenhower said none of this. Been nationalized, and he sent the U.S. Army in to enforce the provisions of the Supreme Court. And Eisenhower, by the way, was no particular fan of Brown versus Board of Education. He thought it was moving too quickly. He just thought this was social norms rather than illegal discrimination.
Right.
But he nonetheless thought it was important to send the message,
that this is the decision.
Yeah. So we go back to Thomas Paine. So the section that I best like in Common Sense is he says, let the world know that in America, who is king?
The
Remember?
law.
What?
The law.
Yes. In America, the law is king.
Mm-hmm.
And he actually imagines, let's get a crown and put it on top of the law, that the people will know that in the United States, the law is king. And it's awkward. Now, sometimes a court can be persuaded to change its mind, and sometimes it makes bad decisions. It's not perfect,
Right.
but it's probably more perfect. We look for a more perfect union. It's more perfect to have an institution that is not directly vested in popular, trying to appeal to the populace,
Right.
and trying to interpret what the Constitution says and means, than it is to give that to the president or to Congress.
Yeah, and in this case, so this is a huge question, is there's open question as to whether Trump, Elon Musk, DOGE, any other organization will simply defy any court order against them. And in some cases, it appears that they are right now, that there's been a preliminary injunction against the freezing of different public federal aid. And at least in some states, it appears that that has not been followed, that those funds are still frozen and have not been released despite the preliminary injunction.
Right. They haven't said they're defying the court to this.
Correct. They haven't said it.
Although J.D. Vance, who is a
Yes.
Yale Law School graduate,
Yes.
Yale needs to apologize. Well,
I honestly agree.
You can't blame the school. Okay. But you have a lawyer from a Ivy League school basically saying, they're all equal. So president does what he, and there, there is something, there's an old theory known as departmentalism, which is each branch sort of interprets the Constitution for itself, but ultimately that doesn't work, right?
No.
Ultimately, you have to have somebody who makes a final decision.
There has to be, it's like any organization is who's the deciding vote. If we have a split, there has to be a decision maker. There has to be one final deciding vote, deciding factor, who trumps the other. If you have a company that's 51-49, if they disagree, the 51% wins. And it's not that they're more important, it's just that deciding vote. And in this,
and one of the beauties actually of the court, one of the reasons I've studied it for 50 some years, is that the court gives reasons for its decision. Now, members of Congress often do, but there are 500 and some of them.
Right.
It's hard to know which one. Presidents sometimes do, but they don't have to.
Correct.
Whereas when the Supreme Court gives a decision, they give you reasons for it.
Huge opinions.
That furthers, that's not as arbitrary as just, I'm firing you and I don't have to give you a reason.
Correct.
They give a reason, and the public has access to it. Attorneys have access to it.
Right.
And over time, we've looked at some of these decisions and say, well, those reasons are inadequate.
Exactly.
And, you can overturn a Supreme Court decision by constitutional amendment.
Right.
It can be, the court itself can look back, as they did in Brown, and say, Plessy versus Ferguson, 1896, we upheld separate but equal, but we no longer do so.
Right.
So,
even with the recent abortion decisions.
Well, that's right. And again, one of them has to be wrong, right?
Right.
At least one of them.
Right. But but the issue is, when it was first done, right, with the original Roe versus Wade, ultimately it was decided by the courts that abortion is legal.
Well, most abortions.
Yeah, I'm simplifying it, right?
Yeah.
Most abortions, not all, but most abortions are legal. And that was the law that was followed because it was the courts or the Supreme Court's order that this is the correct interpretation of the law and the Constitution. So it was followed. Now we get into the new case. The Dobbs decision, and the Supreme Court has said we've decided that that's not the correct interpretation. We've decided that we're not outlawing or permitting abortion. We're
Up to the
sending it back
states.
to the states to decide.
Right.
And that has now been enforced because that is now the current interpretation.
And the president has said, this is on me. I proudly appointed 3 people to the court.
Right.
All of them voted the right way as he sees it. And the dilemma that he's in is, if we're not going to support the court when it rules against, I'm going to rule against the courts when it rules in a way that I like, but I'm not going to favor it when it doesn't.
Right.
It's sort of inconsistent, right?
Exactly. You can't
That's
pick
how
and
we all
choose.
want it, right? It's I win, tails you lose.
I would love to tell a jury they're wrong. I'm going to get another jury.
Yeah.
Or tell the judge, really, that was a bad decision. I'm going to forget that you said that. And
Good luck with that.
Right? But
Please don't get disbarred.
I don't want
I
to
supported you long enough.
That's very true. But here's the ultimate issue, right? Is if the president says, I'm going to disregard the law, this decision, whether it's a district court decision, an appellate court decision, or the Supreme Court decision, if the president says, I don't have to do that, I have power in and of myself, they're a separate branch, they can't tell me what to do, let's look back at the rank and file. This floats down from top to bottom. And in my cases that I take to court in district or circuit court level, not always up on appeal, it's not as often, but what gives, tells my clients that they shouldn't violate their court decision. Well, if the president doesn't like his decision, he doesn't have to follow it, so why should I? It's an ultimate question then, not just of the judicial system or the judiciary, but of the system as a whole, is if we can defy and pick and choose which court decisions we follow, which we disregard, which we defend, whatever it is, I think that is a complete undermining of the entire judicial system, which seeks to enforce orders by the court, whether that's a final order of guilty or not guilty, whether that's a final order of liable or not liable, whether that's a preliminary injunction. If the president doesn't have to regard it, if the vice president doesn't have to, if Congress looks and says, well, we don't agree with your interpretation, then where does that leave the third branch, the judicial branch of having, well, we're the ones who know the law, we have final say over what it means, and they must follow it. Like Nixon had to follow the law.
Let's make a slight distinction just so people aren't confused. On constitutional issues, it's generally accepted that the court has final say. That can be overturned by amendment.
Correct.
On statutory
Congress
issues,
can amend the Constitution, but it's a hard process.
Congress and the states. Then if it's a matter of what the law means as opposed to the Constitution, Congress can come back and say, you misinterpreted what we said. This is a new statute that now covers it. So there is a way
to create new law.
Right. Or clarify the meaning of an old law.
Right.
So there are ways to deal with, it doesn't mean, and that's why, the Supreme Court is not ultimately supreme. Ultimately, we the people, as expressed through the processes of a constitution that we have long revered, and rightfully so, that's supposed to be the ultimate rule here.
Right.
And hopefully.
But that's the issue, is even if we say the Supreme Court's not the ultimate because we have other processes, the processes are still related to the law. That Congress, based on the Constitution, then creates new law. Or Congress creates another amendment. It amends the Constitution through Congress and the state, and there's a large process procedurally written based on the law. But for
we're all in such a hurry, right?
Yes,
so
everyone is.
We want and praise. We deserve this in a way. We always praise Franklin Roosevelt for everything that he did in the first 100 days.
How decisive he was, right?
Trump is going to show us that he can do just as much in the first 30 days or 60 days as earlier presidents have done. We're all in a hurry. I will say that the other thing to remember about the three branches and I got more flack for an article I wrote on this than any article that I've ever written.
Oh my goodness.
But I wrote an article, some of it mean, but anyway, I wrote an article basically saying Trump is a legitimate president. He won both the electoral and the popular vote,
Right.
but he has a limited mandate.
Right.
He has a very narrow majority in both houses of Congress.
And
he won by actually less than a majority of the vote, which makes him no less president.
Correct.
But to claim he has no bigger mandate than did Obama or Clinton or Bush's or any of the recent presidents.
Right.
He has and again, I'm not at all denying that he has a right to exercise executive power, but he didn't come in through a landslide. And all that's really lacking right now is we have a branch of government. If they want to cut pay, they ought to cut pay of members of Congress who are unwilling, unwilling to stand up for what they believe. They have a duty to interpret the Constitution too.
Right. They write the laws.
See the Constitution. All three branches do. And when a branch rides roughshod over the Constitution, the people shouldn't say, well, he's of my party.
Right.
Or he helped get me elected. They ought to say, my first responsibility is to uphold the Constitution. And what you are seeing in this last week, and it's hard to know how representative it is, but you've seen a couple Congress members going back to their districts and getting an earful. And people saying, why aren't you standing?
Us.
People in this district are being fired and you're not standing up for them. People in this district are seeing, this happening, and that's not what they voted for.
Right. You're our representatives.
Yes.
You're the representative of this state and this district in this state. You are not representative of this party necessarily.
Well, and I mean, they are in a sense, but
but it's,
what are you going to put first? The interest of the people of this district and this country, or the interest of the leader of your party?
Correct. And each person who is brought in, whether it's the president, a congressperson, or Supreme Court justice, they have oaths that they take the Constitution.
And the oath used to mean something.
Yeah. To uphold the Constitution.
Yeah. I mean, there were people in early American history, including, if I remember, John Quincy Adams, who resigned their seat because they did not think they could carry out the will of the people of their district without violating the Constitution. So and people took, when the oaths were put in the Constitution, it was at a time where people thought that if you broke your oath, you were likely to go to hell. I mean, it was a very serious thing. Right. And it still should be serious. If you can't if you can't uphold the Constitution, go somewhere else.
Well, and that's why we've seen some of the Department of Justice officials actually leaving their jobs. This is regarding Adams back in New York, is they were told, you've got to drop the case. And some of the prosecutors have said, I can't do that.
That's right.
I don't believe legally that this should be happening, so I'm resigning because I will not do that.
Let's go back 50 years again to near the bicentennial. What was it that what happened? President Nixon decided to fire Archibald Cox, who was a special prosecutor investigating Watergate.
That's right.
And so he turned to Elliot Richardson, his attorney general, and he says, fire him. And he says, I won't do it. I resign. Then he turned to Ruckelshaus, his associate, fire him. He said, no, I won't do it. It's unconstitutional. He resigned. Came to Bork, and now there's still discussion, Robert Bork, whether he did it because he thought the president had the power and he didn't have any problem with it, or, as apparently happened in the case of Adams, somebody down the line said, look, we can't all resign. I'll resign. I can get it. I can write a book. I can get another job.
Yeah.
The people below me may not be able to do that, so I'll take the hit. I'll do something I think is wrong legally simply to protect the rest of them. And now we have, I would assume, not assuming, U.S. attorneys that is a prestigious and powerful position.
Extremely so in the attorney world.
I mean, it's the height, sort of, other than being a judge.
Of course.
People don't give up jobs willingly.
No.
I mean, they might if they're 70 or well. To go to a related issue, you have an 88-year-old pope.
Yes.
Who, many people now. Apparently, he has a great work ethic.
Right.
Can work, but you would think maybe he would say, God's speaking to me first, first one lung, then the next. Maybe he wants me to resign. He's holding on to power. And when somebody has enough ethic, I mean, these people ought to be put in the congressional or the judicial hall of fame somewhere.
Right.
Somebody stands up and says, I'm willing to give up my job and my security because I'm upholding the Constitution. They're the kind of people that ought to be elected to office.
Absolutely. And
Anyway,
that's the
hats
struggle.
off to them.
Yeah. And as an attorney, I have so much respect because whether they're right or wrong,
That's right.
legally, the idea of they do not believe ethically as a lawyer that they can follow that direction, so they are stepping down. That I'm barred in 3 jurisdictions: DC, Virginia, and Maryland.
Okay, be careful when you say barred. You're not barred from them, okay?
No, not barred from them. I'm barred in them as an attorney. I'm legally allowed to work in them. I passed 2 bars and then did reciprocal for DC. But with each of them, we have in each state a code of ethics. It's usually called professional responsibility or the code of professional responsibility. Most of them are the same. All 3 of them have extremely similar phrasing, responses. Even some of their numbers are the same. But overall, there's a code of ethics, whatever state, whatever jurisdiction you're in, that you have to follow. And as an attorney, I question this every day, right? I'm looking, the pit of my stomach falls if there is any question or idea that I broke a rule of ethics, that I didn't follow it. And I mean, maybe I'm the majority.
And places you can consult, right?
Absolutely.
An attorney
there are
can
hotlines.
Yeah.
Yes, there are state
And that's
hotlines.
your obligation, right?
It is.
I've been put in this position. I don't know what to do. Give me some advice.
And
I want to do it right.
Exactly. And the people there are usually part of the bar association or the ethics part of the bar association or bar council that usually say, okay, thank you for telling me this information. It's usually secretive, where you call in confidentially, you tell them about an experience, they give you what they believe is the ethical advice for your legal situation, and you follow it. And I'd like to think that most attorneys would say, what am I ethically required to do based on the code, the law, even the base Constitution? I struggle with this, daily because I want to do it right. And lawyers are really disregarded in that sense of a lawyer's a shark. There's, so much talk about lawyers aren't ethical. Even in my own profession now as a personal injury attorney, we're looked at as ambulance chasers. Some of them are. Yeah. Some of us are. But for those who have an oath, who are bound by ethics and professional conduct, can we look at ourselves on either side, whichever side it is, and say we have a duty to the law? What is the law? What is our duty? How is the law being interpreted? What is our response to the courts, to Congress, to the president? And may we each determine what that is as our own responsibility as lawyers.
And there is a downside, right?
Yes.
I mean, you should be ethical because you should be ethical.
Correct.
But in some cases, if it's found that a lawyer has administer the law with fear or with favor, they can be disbarred.
They absolutely can.
I mean,
yes.
And it's a terrible thing to put a person in a catch-22 position where, if you follow these orders, you keep your job, but you might later be disbarred.
And that's often a quandary with associates. So the supervisors, there are specific rules where it says if you follow the rule or the guidance of your supervisor or your superior, let's say it's a partner at a law firm, and they tell you to do something as the associate and you're not ethically allowed to, the bar doesn't give you credit because you followed the superior's orders. In fact, it says you can't. You cannot follow it just because you will lose your job, just because you will be looked down upon or your salary will be decreased or whatever. It says you still have an ethical responsibility wherever you are on the totem pole, and you will not be relieved of that responsibility if you were ordered to do it and you did it, because it's still unethical. So, Dr. Weil, I appreciate you being here. It's been great to be doing the Legal Weekly Wine with you. And a shout out to our other co-host, Chelsea Rogers, who has been doing this for 2 years with us as well. Very exciting. It has been literally over 2 years now, 100th episode. She has been in over half of them. I would say almost 2/3 of our episodes. And shout out to her. We love you. We miss you. Hopefully we can get you back at least on a couple of episodes. But she's doing a fantastic job. She is looking for a job in her own state right now. She's our Georgia peach, and she's decided to stay down in Georgia. We wish her well and hope that she, we are, whoever finds and snatches her up as an employee is a very lucky office indeed. So we wish you luck, and thank you everybody for joining us on this 100th episode, and we look forward to seeing you next time on the Legal Weekly Wine.